everyone, and welcome to Daily Newspaper Analysis, which is brought to you by LawSikho. So, today we will discuss two articles. The first article is from The Hindu, which is titled as Will a National Judiciary Work? So, this article talks about the feasibility of having an All India Judicial Services examination as against the state judiciary examinations that we have currently. The second article is from the Indian Express, which is titled as Reading Section 43D, Clause 5, How It Sets the Bar for Bail for High. So, this article talks about this particular section of the Unlawful Activities Prevention Act, and basically it talks about the case of Stan Swami as well, who has recently expired. So, what is this section and how it makes the provision of bail very, very difficult under UAPA has been discussed in this article. So this newspaper analysis is presented to you by me. My name is Sheba Khan and I am a law graduate from 2019 batch and I have been a gold medalist as well. Here at LawSikho, I'm working as current affairs expert and manager for current affairs vertical. If you wish to connect with me, you can find me on my Twitter as well as LinkedIn handles. The description to both are mentioned in the description box below. Also, there is a very important announcement that we need to make for all the people who are preparing for judicial services examination. So if at all you face any problem in understanding the syllabus of judiciary or how you should start the preparation for judiciary, or in a way what can be the right guidance for your exam preparation, so you can definitely join this free online 3-day boot camp on how to crack Indian judiciary exams. So this is entirely and completely free bootcamp program, and this will be held on 11th to 12th July 2021, and the time is 6 p.m. to 9 p.m. So you can register now itself. You can find the link to register in the description box below. And definitely, if you're serious for your preparation or have any confusions with regard to that, definitely go and participate in this bootcamp. With this, let's see what is the multiple choice question from yesterday's discussion. The legal status of salva jurum is, your options are constitutional, unconstitutional, not illegal, or none of the above. If you know the answer, you can put it down in the comment section below. This is the descriptive question for the day. How much do you think that the idea of all India judicial services is feasible in the Indian judicial system? Give reasons for your answer. Also, if you wish to download the PDF of these slides or you want to avail other study material like the monthly current affairs magazine, quizzes, etc., you can participate or join our Telegram channel. The link to the channel is also there in the description box below, or you can simply scan this QR code which you can see on your screens right now. Also, do not forget to follow us on our official Instagram channels for Judiciary, CLAT Prep and LawSikho for UGC.net as well. With this, let's start our article for the day, which talks about the All India Judicial Services. So the Union government in 2019 spearheaded a consultative process for the creation of All India Judicial Services. So now we have been recently having the discussions about having the All India Judicial Services examination. So as we know that currently the judicial examinations or the judiciary examinations in India are conducted depending upon the different states. So basically we do not have an all India service, but rather it is a state service. But now the debates are coming around that we should have an all India judicial service examination to bring a more integrated system in the Indian judiciary. This would somewhat be on the lines of the all India civil services examinations. So if we talk about the constitutionality of having the All India Judicial Services, so Article 233 Clause 1 provides that the appointments of persons to be and the posting and promotion of the district judges in any state shall be made by the governor in consultation with the high courts exercising the jurisdiction therein. And if we talk about the 42nd Constitutional Amendment Act of 1976, it amended Article 312, Clause 1 of the Indian Constitution, and it gave the empowerment to the Parliament to make laws for the creation of one or more in all India services, including an AIJS common to the union and the states. So basically, the parliament is empowered to do so, just that it had not used its power till date. And that is why, if at all the parliament comes up to make the all India services for the judicial services as well, it would be very much constitutional under Article 312 of the Indian Constitution. So if we talk about the clause 3rd of Article 312, it provides that the service shall not include post inferior to the DJ, that is that of the district judge. And it was amended, it also amended the entry third of list second, which is there in the seventh schedule of the Indian Constitution. And it allowed the parliament to enact laws with respect to administration of justice, constitution and organization of all courts except the Supreme Court and the High Courts. So if we talk about the courts that are lower than the Supreme Court and the High Courts, then the parliament can be allowed to enact laws with respect to the administration of justice. And thus Article 312 very much empowers the parliament to bring in the All India Judicial Services. So, if the fundamental power of the states to make such rules are taken away, it may be against the principle of federalism and basic structure doctrine as well, because we follow the doctrine of division of powers and separation of powers, and even having the separation of jurisdiction in the center states and even now the panchayats and municipalities. And that is why the federal structure is one of the basic structures and one of the basic parts of the basic structure doctrine as well. And that is why we should not, or we cannot take away this power from the states. So, if we try to understand about the background or the historical development that took place with regards to the All India Judicial Services, so we should know that the first Law Commission also deliberated upon it, and it gained momentum in 1972 with the 42nd Amendment Act as well. But it was not somehow materialized or solidarized in a complete process. And in the early 1960s as well, the issue was debated again during the CJ conferences, that was the Chief Justice's conferences. And the first National Judicial Pay Commission found that the All India Judicial Services is to be in interest and in health of the Indian judiciary. Also, the All India Judges case of 1992, the Supreme Court opined that the recommends of Law Commission be examined and implemented as well. Also, the Union Law Minister said that the All India Judicial Services is an ideal solution for equal representation of all. Now, when we talk about the All India Judicial Services, there are a lot of things that are in favor or that are attached as the merits of having All India Judicial Services, as we will have an integrated system of the selection process would be more uniform, the syllabus would be same for the entire country, and so on and so forth. But there are also some limited but yet existent hurdles or obstacles that might come in the forefront. The biggest one is having different languages. Now, currently what happens is that the judicial services examinations, when are taken care of by the states themselves, so the examinations are conducted in the vernacular languages as well. But when we talk about the All India Judicial Services, so language might be one barrier that might be seen. But still, there is a choice of having the examination or conducting the examination in all the 22 official languages of the country, just the way the civil services examination for the IAS, IPS, etc. is conducted by the UPSC. So this also has a selection criterion for that matter. Like, for example, we should know that for the district judge, there is a mode of recruitment by promotion on the basis of merit cum seniority. Then if we talk about the district judge on the selection grade, so it is done by promotion on the basis of merit cum seniority again. And thus there are different kinds of, the selection criterion which are followed in the Indian judiciary. So now let's discuss the second article of the day, which talks about bail under the Unlawful Activities Prevention Act. So 2 days before Stan Swamy passed away, he moved the Bombay High Court challenging Section 43D Clause 5 of the Unlawful Activities Prevention Act. So before we begin, let me tell you that Stan Swamy was a very well-known tribal rights activist, and he had been also put into jail using the provisions of Unlawful Activities Prevention Act. So before we begin, let's also understand as to what is the Section 43D Clause 5 of the UAPA. So this talks about the modified application of certain provisions of the code, in which it talks about the provision that notwithstanding anything contained in the code or any other law, every offense punishable under this act shall be deemed to be a cognizable offense within the meaning of Clause C of Section 2 of the code, and Section 167 of the code shall apply in relation to a case involving an offense punishable under this act. So basically this section makes the bail provision very much difficult under the UAPA. So let us talk about the provision in detail. So it was enacted in 1967, which was strengthened by the Congress-led UPA government in 2008 and 2010. Now, in this time, there was a test which was put for denying bail, that if at all the court has to deny the bail in this situation, so what test needs to be applied is that the court must be satisfied that a prima facie case exists against the accused. And if at all the court is satisfied with this thing, now prima facie is something that is visible on the face, which is patent and not latent. So, which means that something that is very much visible, so such kind of case must exist against the accused. And if it does, then in such situation, the bail may be denied. But otherwise, the bail should be granted. So, if we talk about the 2019 judgment, the Supreme Court defined prima facie narrowly to mean that the court must look at the totality of the case presented. So, it actually narrowed down the meaning of prima facie in 2019, and it said that the court should still look into the entirety or the totality of the case and then should decide whether or not the bail should be granted. So, if we talk about the courts granting bail, so in the case of Union of India versus K.A. Najib in 2021, it upheld the bail under UAPA when the accused had undergone incarceration for a significant period. So even during the trial, he had been during the jail for a very long time, and that is why his bail application was granted. In February 2021, the Bombay High Court granted bail to Telugu poet Varavara Rao. Holding bail under UAPA can be granted by the Supreme Court as well as the High Court purely on grounds of sickness and advanced age as well. And finally, very recently in June 2021 itself, the Karnataka High Court granted bail to over 115 accused. And that is why we should understand that bail is a general rule and jail should be an exception. And if we talk about the appeal against the High Court rulings, so in June 2021, the Delhi High Court, while it granted bail to three student activists, circumvented the stringent bail provision under the UAPA by question that if the alleged offences qualified as the terrorist offences or not. And if they did not, then the bail should have been granted. Now, on appeal, the Supreme Court stated that the High Court ruling cannot be used as a precedent till the appeal is decided. And in 2018, the Delhi High Court, in the case of Zahoor Ahmad Shah Watali versus the National Investigation Agency, held that the trial courts must not act merely as a post office of the investigating agency, and thus it should be taking care of the fact that it should investigate or it should look into the matter very closely and only then decide upon the merits of the case. And the Supreme Court rejected the High Court's decision that materials by the IA must be carefully examined. That is, if whatever materials or the documents are provided by the intelligence agency, so they should be properly examined before giving the judgment. So this was all for the day. We hope it was a good and it was a learning session for you all. If you liked it, please give it a thumbs up and also subscribe to our channels for such more updates to come. Thank you so much.